Welcome, everyone, to The Deep Dive. I'm your host, and if you're anything like me, your newsfeed can often feel less like a gentle stream and maybe more like a fire hose, right? Headlines just blast out, breaking alerts are constantly buzzing, and there's this, constant churn of information. It's incredibly easy to feel overwhelmed, especially when it comes to figures who seem to be perpetually at the very epicenter of national attention, driving just countless narratives. Today, we're embarking on a deep dive designed specifically to cut through that relentless noise. This deep dive in particular is kind of custom tailored for you, the listener. We've taken a really comprehensive stack of sources. Everything from in-depth articles and academic research to our own meticulously gathered notes. And our mission today is to extract the most important nuggets of knowledge and insight. Today, our focus is laser sharp. We're going to unpack the incredibly complex legal and political landscape surrounding Donald Trump. This means delving into his recent, often quite unprecedented courtroom setbacks, exploring the, lingering shadows of past associations that continue to surface, and dissecting the intricate internal dynamics that are currently reshaping the very political party he leads. It's a vast amount of ground to cover, I know, but we're going to make it not just digestible, but genuinely illuminating.
That's absolutely right. Think of this as your definitive shortcut to being truly well-informed without getting bogged down or feeling, buried in an avalanche of details. We'll meticulously synthesize information that spans these high-stakes civil lawsuits, fundamental challenges to the very limits of presidential power, and even the unfolding future of one of America's major political movements. Our goal extends beyond merely relaying facts. It's about empowering you to understand what's truly important, why these developments matter in the grand scheme of things, and what the long-term implications might be for our country and its foundational institutions. We're aiming for those distinctive aha moments, the ones that make even the densest topics kind of click into place, providing clarity and sticking with you long after our conversation concludes.
Okay, let's unpack this. And we're going to start with the truly significant and, frankly, historic development unfolding in the courts, the E. Jean Carroll cases. You see, this isn't just, another lawsuit. This represents a really pivotal moment where an individual, E. Jean Carroll, demonstrated incredible fortitude by standing up against a figure of immense power, someone who, for years, seemed almost untouchable, consistently sidestepping accountability. We've witnessed a pattern of tactics from relentless stalling at appeals to simply, dragging things out indefinitely. But Carroll, a respected journalist, a gifted writer, and a courageous survivor, she hasn't only fought back with unwavering determination, but has actually succeeded in holding him legally responsible for sexual abuse and defamation.
And what's particularly striking here is just how profoundly historic Carroll's actions are. Really, for someone of Trump's stature, being held legally accountable in this manner is a truly rare occurrence, almost unprecedented. She's not just won in court, she is now positioned to collect nearly $100 million in judgments against him. We are talking about a sum rapidly approaching 9 figures.
9 figures.
Right, potentially even exceeding it with all the accrued interest. This financial accountability alone powerfully signals the sheer seriousness and undeniable weight of these verdicts. It underscores a crucial principle. Even the most powerful figures in our society can, and sometimes will, face tangible legal and financial consequences for their actions. It's a powerful validation of the justice system's potential, even when it's tested against immense influence.
So let's walk through exactly how this unfolded. In 2023, after a highly publicized trial, a New York jury delivered a landmark verdict. They found Donald Trump liable for sexually abusing Carroll back in the mid-1990s. The specific incident, as many will recall, occurred in a dressing room at the luxury department store Bergdorf Goodman. But the jury's findings didn't stop there. They also found him liable for defaming her, specifically by publicly dismissing her claims with, a barrage of insults, outright denials, and just relentless name-calling.
And that initial jury in their 2023 verdict hit him with approximately $5 million in damages. $5 million.
Which is not insignificant.
No, not at all. To provide context, that was, by any measure, already a massive verdict on its own. It delivered a clear, unequivocal message from the jury. What he did to Miss Carroll and how he subsequently reacted was legally and morally unacceptable. It was a substantial finding that, frankly, most public figures would have taken as a very severe warning.
But instead of internalizing that message or, learning his lesson, Trump doubled down. While still facing the direct fallout from that initial trial, he continued to publicly attack Carroll. And he did so using the exact same types of derogatory statements that had led to the first lawsuit in the first place. He wouldn't stop.
And this, crucially, led to a second lawsuit and another distinct trial. This time, the jury demonstrated they simply weren't having any of it. Their message was even more emphatic. They slammed him with an $83.3 million judgment. Yes, over $80 million solely for defamation.
$83.3 million, wow.
And what's paramount to understand about this second verdict is that the vast majority of that sum constituted punitive damages. That's essentially the jury making a powerful, deliberate statement. We are going to make this so financially painful for you that you will never even contemplate doing this again. This vividly highlights a clear, unrepentant pattern of behavior and its significant escalating legal repercussions. It really prompts the crucial question: what does such an overwhelmingly strong punitive message from a jury signify about their perception of a defendant's conduct and the determination to ensure deterrence, not just for the individual, but maybe for others observing?
Yeah, it's just a deep frustration, doesn't it? A sense that accountability hadn't sunk in. Now, as you'd expect after these staggering verdicts, Trump appealed both cases. His legal argument hinged on a concept known as Westfall immunity. The core idea behind this, for those unfamiliar, is that if a federal employee acts within the scope of their employment, they can be immune from personal lawsuits for those actions, with the government potentially stepping in as the defendant. Trump's team argued that because he was president when some of those defamatory statements were made, they should be considered official acts, making him immune from personal liability.
However, the courts have decisively rejected this argument. It's important to understand that Westfall immunity isn't some kind of blanket shield just for holding high office. It narrowly applies to actions taken within the actual scope of federal employment. And crucially for Trump's defense, his lawyers didn't even raise this specific defense properly or at the appropriate time in the initial proceedings. They effectively missed their procedural shot.
Oh, so procedural error too.
Yes. And the broader significance here is immense. It underscores the immense importance of legal procedure and timing. It demonstrates that even a figure as high profile as a former president is subject to the stringent rules of the court. The original $5 million judgment is now essentially rock solid, having been affirmed by the appeals court. The $83 million verdict is still winding its way through the appeals process, but E. Jean Carroll undoubtedly has the legal wind at her back. And every single day, interest continues to pile up on that sum, meaning the final amount she could collect will potentially increase well beyond that initial $100 million mark.
Okay, here's where it gets really interesting, delving into some of the most, well, surreal and impactful courtroom moments. During a deposition, E. Jean Carroll's legal team presented Trump with a photograph from the 1980s. The picture clearly showed Carroll, her then-husband, Ivana Trump, and Trump himself, all four of them. And Trump, looking directly at this photo, insisted quite emphatically that the woman who was clearly E. Jean Carroll was, in fact, Marla Maples, his second wife.
He confused her with Marley Maples.
Yes. Just pause and think about that for a second. He had previously claimed Carroll wasn't even his type, and here he was confusing her for a woman he actually married and had a child with. The sheer absurdity was just palpable.
That specific slip-up didn't just subtly undercut his defense. It absolutely obliterated his credibility in front of the jury. It was a moment of profound self-sabotage. What's particularly noteworthy here is how seemingly small, unscripted moments, a misidentification, a moment of confusion, can have these massive and disproportionate legal consequences. They profoundly influence the jury's perception of truth and believability. It's a powerful reminder that in a courtroom, it's not just about the cold, hard facts. It's also about how a person presents those facts, and maybe more importantly, their own character and sincerity. The jury observes everything.
And then there was another incredibly dramatic moment during the second trial. During closing arguments, while Carroll's lawyer was delivering her final impassioned plea to the jury, Trump actually stormed out of the courtroom. I mean, imagine that. A former president walking out on a jury in the middle of a high-stakes trial that directly pertains to his own conduct. It was just a stunning display.
E. Jean Carroll later recounted that this precise moment was when she felt this surge of confidence, realizing the jury was truly with her. She said it was a visceral mirroring of the dismissive, arrogant behavior she had endured from him all along. This prompts a vital question. How do such public displays, particularly from a defendant in a high-profile case, impact the perception of justice and accountability, not just for the immediate jury, but for the wider public observing the proceedings?
Right, it speaks volumes.
It speaks volumes not just about his demeanor in court, but about a consistent behavioral pattern, reinforcing the plaintiff's narrative in a way maybe no testimony could.
So, with these crushing verdicts, what's the immediate next step for Trump in these cases? Well, his legal options are narrowing significantly. His only realistic option left seems to be to appeal both judgments to the Supreme Court.
Now, under normal circumstances, the Supreme Court typically wouldn't even consider taking a civil case like this. We're talking about private citizens focused on damages for sexual abuse and defamation. These simply aren't the types of cases the court usually grants review to. They don't generally involve major constitutional questions or, splits between the circuit courts. However, the caveat, as always in this particular legal landscape, is because it's Trump, you truly never really know.
Always the wild card.
Exactly. If the Supreme Court ultimately decides to pass on the appeals, E. Jean Carroll could begin the process of collecting those judgments within a matter of months. If Trump's appeals are somehow accepted and the case drags on, it could theoretically extend into 2026 or even beyond. But crucially, the interest will continue to accrue on that massive sum, potentially increasing the final number significantly beyond the $100 million mark. And E. Jean Carroll has already publicly stated her intentions. She plans to set up foundations and utilize the funds for causes that will, in her words, drive Trump absolutely crazy.
Like poetic justice, perhaps?
That's the term many are using. This isn't just about financial remuneration. The broader significance here speaks to a profound desire for what many would describe as poetic justice, a form of vindication and impact far beyond mere personal enrichment. So the profound bottom line here is clear. E. Jean Carroll demonstrated incredible courage, standing up when so many others were silenced or intimidated by such a powerful figure. She confronted Trump directly in court, she beat him not once but twice, and she is now on the precipice of holding a former president financially accountable in a manner that is truly unprecedented in American legal history. Her story serves as a powerful testament to courage, to persistence, and ultimately to the enduring power of truth, even when confronted by a public brand built entirely on bluster, denial, and intimidation. It's a landmark case that will resonate for decades.
Okay, shifting from the individual battles in the courtroom to the intricate and often shadowy networks of connections that underpin power. Let's now pivot to one of the darkest and most disturbing questions tied to the Jeffrey Epstein case. How many victims were there, truly? This isn't merely about abstract numbers, it's about grasping the sheer horrifying scale of his operation, understanding the culpability and accountability of those who surrounded him, and dissecting how an entire system, whether wittingly or unwittingly, allowed this man to operate unchecked for decades. And something very significant just happened recently in a Manhattan courtroom that could finally force greater transparency about those elusive numbers. To properly set the stage, let's rewind a bit. For many years, officials frequently downplayed the massive scale and reach of Epstein's network of abuse. When the Trump White House notably weighed in on the Epstein case back in 2019, they issued a memo that seemed designed to just slam the door shut on further investigations. It effectively stated there is nothing more to see here. No definitive client list to worry about, no compelling reason for more criminal investigations, and certainly no further disclosures needed. The clear intent was to wrap everything up neatly. But here's the truly jaw-dropping contradictory part. In that very same memo, for the first time ever, the federal government disclosed a staggering figure.
This is incredible.
According to their internal review, supposedly based on meticulously examining around 300 gigabytes of Epstein's digital data emails, flight logs, unsettling photographs, other physical evidence, Epstein had harmed over 1,000 people. Over 1,000 victims.
Wow.
The utter contradiction is stunning. That revelation came from the very document that simultaneously insisted there was nothing more to investigate. What's more, the government never fully explained the methodology behind how they arrived at that specific figure, nor did they ever publicly release the underlying files that supported it.
What's particularly astounding here is precisely that inherent contradiction. The simultaneous declaration of official closure alongside the revelation of a sheer, terrifying scale of abuse implied by their own internal numbers. They produced a number that was astronomical, yet provided no transparency on its derivation, nor did they release the underlying files. It just leaves this significant and troubling gap between what was stated and what was actually substantiated.
It really creates an immediate tension for anyone looking at the facts.
Absolutely.
Fast forward to this year, and we're seeing this inherent contradiction playing out in a federal courtroom in Lower Manhattan. Epstein's estate is now pushing back hard, aggressively challenging that 1,000-plus victim number the government cited.
And there's a very clear, powerful financial motivation behind this challenge, of course. Victims are currently pursuing a massive class action lawsuit, and a higher validated victim count translates directly into absolutely massive liability for the estate.
Makes sense.
So the estate has every conceivable incentive to argue that the number was exaggerated, that the figure is inaccurate, or that it cannot be substantiated. And here's why this matters profoundly for public transparency. When two powerful sides aggressively argue about numbers in open court, judges frequently and unequivocally demand evidence to back up those claims. This means there's a very real potential that the public might finally gain access to and learn more about what was truly contained within those 300 gigabytes of files that the government analyzed.
So this could actually pry some information loose.
It could. This raises a crucial question. Will this heated legal battle finally force out information that has been hidden from public view for years? Will it finally shed light on the true, horrifying scope of Epstein's operations and network? It's arguably one of the last best chances for that level of disclosure.
Let's step back for a moment and examine the disturbing operational model of Epstein's network itself. Prosecutors and investigators have long compared it quite aptly to a pyramid scheme. And that's not merely hyperbole. Here's how this insidious system apparently worked. Epstein would typically pay vulnerable high school girls a relatively small sum, a few $100s, for what he termed massages. These sessions almost invariably escalated into sexual assault. Then, in a truly sinister twist, he would pay those same victims to recruit their friends, and those friends in turn would recruit more friends, creating this horrific exponential growth in the number of individuals ensnared in his web of abuse.
This deeply disturbing system precisely explains how his predatory web managed to spread so far, so fast, and so thoroughly. Investigators have meticulously traced this cycle of abuse back to the early 1990s, and the comprehensive Virgin Islands investigation discovered it was still actively functioning as late as 2018. That's a staggering nearly 3 decades of sustained operation.
3 decades?
And the scale wasn't confined merely to time. It spanned immense geography. His operations spanned New York, Florida, New Mexico, the U.S. Virgin Islands, and thanks to his ties with known modeling scouts like Jean-Luc Brunel, his insidious reach extended globally to Paris, London, even South America. The broader significance here is chilling. It illustrates how a meticulously designed, financially supported system of abuse can function and expand for decades across multiple continents, leveraging existing social networks and preying on vulnerabilities with chilling efficiency.
Now, here's one chilling detail revealed in a deposition that really underscores just how relentless and predatory Epstein's mindset was. A victim recalled Epstein explicitly telling her he needed 3 orgasms a day, describing it not as a desire, but as the biological necessity, like food or water.
That statement provides a truly disturbing window into his mindset, a profound sense of entitlement, and a complete dehumanization of his victims. Combine that kind of deeply disturbed mentality with decades of unchecked opportunity, virtually unlimited money, incredibly powerful connections, and a meticulously designed system to silence victims and thwart justice. And suddenly, that 1,000-plus victim count doesn't sound far-fetched at all.
No, unfortunately not.
In fact, many experts believe it might even be a conservative estimate, given the duration and global reach of his activities.
After Epstein's death as part of the legal proceedings involving his estate, a compensation fund was established for victims. Approximately 250 applications were submitted to this fund, with 150 of those ultimately deemed eligible for payouts.
But here's the critical limitation and the sobering truth about that fund. Many, many more victims never applied. Some simply couldn't bring themselves to relive the profound trauma by going through the application process. Others lived in fear of retaliation, even after Epstein's death, or just didn't trust the system. And tragically, some victims had already died, including some who took their own lives due to the lasting impact of the abuse. So, while 150 victims were officially recognized for compensation, that's undoubtedly just the very tip of a much larger, more tragic iceberg.
Just scratching the surface.
Exactly. This prompts a crucial question. How do we even begin to accurately measure the true impact and scale of such widespread abuse when so many profound and traumatic factors prevent full disclosure and reporting from the victims? It highlights the immense difficulty in truly quantifying the scope of such crimes.
The individuals who served as the administrators of Epstein's estate and who oversaw this compensation program were 2 men named Darren N. Dyke and Richard Kahn. These weren't peripheral figures. They were intimately part of Epstein's inner circle. For over 20 years, they were responsible for handling his sprawling finances and complex legal affairs.
In fact, the Virgin Islands investigators went as far as to describe them as the indispensable captains of his entire abusive operation. This suggests that without their meticulous logistical and financial support managing offshore accounts, shell corporations, property acquisitions, Epstein's entire machine might not have functioned with the sinister efficiency it did.
So enablers, essentially.
That's the implication. What's particularly compelling here is the deliberate shift in focus beyond just the primary abuser to those who enabled the systemic abuse, highlighting a broader network of accountability. Victims later filed a separate lawsuit against Indike and Khan in federal court, alleging they personally helped sustain Epstein's criminal enterprise through direct payments and shady transactions. Indike and Khan staunchly deny all allegations. It's also noteworthy that the judge presiding over this case is the same one who recently handled other high-profile complex trials, including those involving Sean Diddy Combs. This indicates a courtroom environment deeply experienced with intricate, high-stakes legal battles involving prominent figures.
And just when you think the story can't get any stranger or more interconnected, there's yet another twist. After Epstein died, Darren Indike, one of his longtime estate administrators, landed a new job at a law firm run by Tim Parlator. That name might ring a bell for some of you because Parlator notably represented Donald Trump during parts of the classified documents investigation, and he's also represented other high-profile conservative figures.
Oh.
So what we had here is a direct thread, a very tangible connection between Epstein's longtime lawyer and the Trump legal orbit.
And according to Parlator himself, Indike's work with Epstein, which included things like buying private planes and moving vast sums of money offshore, was considered valuable experience that he brought to the new firm.
Valuable experience.
Right. The broader significance of this connection, host, raises a crucial question about how perceived business savvy or expertise in complex financial structures can intersect with and potentially even be seen as beneficial despite their use in enabling illicit activities. It also significantly impacts the public's perception of such connections within the legal world, raising uncomfortable questions about ethical boundaries and professional judgment. That's precisely why this Manhattan lawsuit is so incredibly important. It has the potential to finally force the full documentation of how Epstein's operation truly functioned, not just at a surface level, but granular details like how he paid victims, how he laundered money through various entities, and who else, if anyone, was knowingly involved in facilitating his crimes. The sobering truth we must confront is that we may never have a definitive, fully verified number of victims. Some stayed silent forever, some are tragically gone, and some critical evidence may remain hidden or destroyed. But what's undeniably clear is that Epstein's abuse wasn't isolated, it wasn't small, and it wasn't just a handful of cases. It was systemic. It lasted for decades. And it spanned multiple continents.
The scale is just immense.
Immense. And when you hear Epstein's estate aggressively argue that the victim numbers were exaggerated, remember, they have immense financial incentive to shrink the perceived scope. And when you hear the DOJ casually drop over 1,000 victims in an official memo while simultaneously insisting there's nothing more to see, that profound contradiction should compel all of us to sit up, pay attention, and demand answers. This case isn't just about the ghost of Epstein, it's about broader accountability for the enablers and institutions that protected him, and for the hidden truth that we know is still locked away in terabytes of files. This ongoing litigation represents one of the last and best chances to crack some of that open for public scrutiny.
Let's shift gears now to an urgent and incredibly complicated battle currently raging across America. The fight over medication abortion, specifically centering on a widely used pill called mifepristone. This is a high-stakes tug-of-war with deeply entrenched positions on both sides. On one side, you have everyday people, dedicated doctors, and tireless advocates working relentlessly to protect access to what they consider safe, legal, and scientifically backed healthcare. On the other, you've got a highly coordinated, well-funded, and incredibly organized network of political operatives, billionaire backers, and strategically appointed judges who are actively seeking to strip away reproductive freedom from millions of Americans. And right in the very middle of that fight is mifepristone.
And it's absolutely crucial for everyone to understand mifepristone's standing within the medical community. It is neither experimental nor medically controversial. This medication has been safely and effectively FDA approved for nearly 25 years. It's utilized in over 60% of all abortions across the country, making it the primary method for early pregnancy termination.
Over 60%.
Right. What's more, it's been proven safer than many common prescription drugs, and even numerous over-the-counter medications that you likely have readily available in your medicine cabinet right now. What's particularly confounding here is the stark, undeniable disconnect between the overwhelming scientific and medical evidence attesting to its safety and effectiveness, and the relentless, ideologically driven political attack on the medication itself. It's a situation where science is actively being disregarded in favor of political aims.
When the FDA initially approved mifepristone way back in 2000, it came burdened with what many considered unnecessary hoops and restrictions. These limitations dictated who could prescribe it and, crucially, how patients could even get their hands on it.
Advocacy groups like EMA, Expanding Medication Abortion Access, founded by Kirsten Moore, recognized early on that these restrictions weren't rooted in scientific necessity or patient safety. They were unequivocally political in nature. These groups spent years meticulously gathering real-world data and filing persistent lawsuits, actively pushing the FDA to acknowledge what the evidence already resoundingly showed. The restrictions were unwarranted.
Then came the unforeseen catalyst of the COVID-19 pandemic. Suddenly, telehealth transformed into the new norm. People were routinely seeing doctors over video calls, getting prescriptions sent directly to their doorsteps. But bizarrely, mifepristone was singled out from this new telehealth flexibility. Despite being one of the safest drugs on the market, the FDA continued to bizarrely require patients to pick it up in person.
Still required in-person pickup.
Yes. Just think about that for a moment. You could easily get powerful opioids prescribed through a simple telehealth visit, but you couldn't get mifepristone, a far safer medication, without an in-person pickup. The double standard was glaring.
That glaring double standard simply couldn't withstand sustained scrutiny, especially as more data accumulated and lawsuits pressed the issue. Eventually, the FDA did loosen those restrictions, finally allowing certified pharmacies to dispense it and telehealth providers to prescribe it. This was an absolute game changer for access, particularly in rural areas or for individuals facing transportation barriers. Now, nearly a quarter of all U.S. abortions are provided via telehealth, a shift that has paradoxically helped to keep abortion rates stable, even in states with increasingly strict bans.
Which probably isn't sitting well with opponents.
No, it's understandably driving opponents of reproductive freedom absolutely furious. This development raises a critical question. How has technology, in this case telehealth, enabled new avenues for healthcare access? And why does this particular shift in medication delivery spark such intensely visceral opposition, especially given the established safety profile of the medication? It illuminates a battle not just over access, but over the very means of access.
So who exactly are these opponents leading this charge? Let's be very clear and name names. Leading the political charge is Senator Josh Hawley of Missouri, a politician who has openly and explicitly made it his mission to roll back abortion rights at every single level, state and federal. And incredibly, his wife, Erin Hawley, serves as one of the top litigators actively engaged in lawsuits specifically designed to overturn mifepristone's federal approval entirely.
Wow, a coordinated effort.
That's right. A sitting U.S. senator and his wife are, in effect, running a coordinated campaign from both the legislative and legal sides to aggressively lock down access to this medication. And their network of allies is extensive. You also have Judge Matthew Kacsmaryk in Texas, a Trump-appointed federal judge who has become the established go-to guy for anti-abortion lawsuits because conservative groups know with near certainty that he will side with their argument.
That sounds like judicial shopping.
It's judicial shopping, a calculated strategy, plain and simple. And then there's Leonard Leo, often referred to as the conservative kingmaker, who meticulously orchestrated the stacking of the Supreme Court with conservative justices, and who now sits on a war chest worth billions, specifically funding this crusade.
Their multi-pronged strategy is sophisticated and relentless. Firstly, they're filing lawsuits that fundamentally challenge the FDA's very authority, claiming the agency never should have approved mifepristone in the first place, despite its nearly 25-year track record of safe and effective use. Secondly, they're pushing for state-level bans, even in jurisdictions where voters have overwhelmingly rejected such measures through ballot initiatives.
Even against voter will.
Yes. And thirdly, and perhaps most disturbingly, they're heavily relying on what can only be described as junk science to construct arguments that mifepristone is somehow unsafe, flying directly in the face of overwhelming scientific evidence to the contrary. For instance, one widely cited study in their arsenal counts any emergency room visit after taking mifepristone as a serious adverse event, even if the patient went to the ER for something completely unrelated, like breaking a bone or even a car accident.
That's not how science works.
That's not science. That's quite literally cooking the books to fit a predetermined, politically motivated narrative. The broader significance here, host, is how scientific data, which should be objective and apolitical, can be deliberately manipulated and distorted for specific political ends, eroding public trust in both scientific institutions and the very process of policymaking. And this is where things get truly dangerous, not just for abortion access, but for the entire regulatory landscape of medicine. If courts establish a precedent allowing groups of doctors who never even prescribe mifepristone to sue to block its access, or if they permit states to override fundamental FDA decisions regarding drug safety and efficacy, then literally no drug on the market is safe from politically motivated attacks.
That's a chilling thought.
Think about the profound implications. If they can roll back access to a medication with a quarter-century track record of safety, what's to stop similar challenges from being mounted against birth control, critical cancer treatments, or even something as common and widely used as Viagra? This isn't hyperbole. This is precisely why major pharmaceutical executives and industry groups have already filed briefs warning the Supreme Court against validating these arguments, recognizing the incredibly dangerous precedent it would set for the entire pharmaceutical industry, the drug approval process, and innovation itself.
Now, let's zoom out and consider the broader political implications here, particularly for Donald Trump. Ever since the Supreme Court overturned Roe v. Wade with the Dobbs decision, abortion has transformed into a political landmine, a persistent electoral liability for Republicans across the country. Donald Trump himself, according to reports, privately said we're in trouble the very day the Dobbs decision dropped, indicating he understood the seismic political shift.
And he was presciently correct. Voters across a wide political spectrum, from deep red conservative Kansas to the purple swing state of Ohio, have overwhelmingly and resoundingly rejected outright abortion bans and draconian restrictions when given the opportunity to vote directly on ballot initiatives. Poll after poll consistently shows a clear majority of Americans support keeping abortion legal, especially in the early stages of pregnancy. And since mifepristone is only used in the first 10 weeks of gestation, the public overwhelmingly perceives efforts to ban it as extreme and out of step with mainstream opinion.
So public opinion is pretty clear.
Very clear. What's especially noteworthy here is how consistent public opinion expressed directly through the ballot box directly contradicts the aggressive judicial and legislative efforts of some ideological groups. This creates a fundamental disconnect that Republicans are struggling to reconcile.
This puts Trump in a real political bind. A classic no-win situation. On the one hand, he desperately wants to take full credit for appointing the conservative justices who ultimately overturned Roe v. Wade, a long-held goal of the anti-abortion movement. On the other hand, he implicitly understands that actively pushing for a nationwide abortion ban would be an act of political suicide in a general election. So he's attempting to, have it both ways, a delicate and often contradictory dance. He promises anti-abortion activists that he's unequivocally on their side while simultaneously telling the broader public that he'll simply leave it to the states.
But let's be absolutely clear about the future implications. If he wins another term, his allies are already meticulously laying the groundwork to impose federal restrictions on abortion through what would effectively be a backdoor strategy.
A backdoor strategy.
Well, this could involve, for instance, attempting to revive and broadly interpret arcane 19th century obscenity laws like the Comstock Act. If weaponized, that could be used to block the mailing of abortion medications and even related educational materials across state lines. Alternatively, they could heavily pressure federal agencies like the FDA and HHS to reimpose severe restrictions on medication abortion, effectively bypassing congressional legislation entirely. It's an attempt to achieve a de facto nationwide ban without the political fallout of a direct legislative fight.
Meanwhile, on the other side of this fight, doctors and advocates are certainly not standing idly by. Blue states, recognizing the threat, are proactively passing innovative shield laws designed to protect telehealth providers who prescribe mifepristone to patients residing in states with bans, creating a legal safe harbor. Organizations are working tirelessly to ensure people know about vital resources like I Need an A and abortionfinder.org, where individuals can discreetly connect with licensed providers and obtain necessary care. And powerful awareness campaigns like MyFinAll 50 are actively raising public consciousness and pushing back aggressively against the torrent of disinformation being propagated by opponents.
The essential bottom line here is that this struggle extends far beyond just one pill. It's about a much larger foundational question. Will a handful of billionaire-backed operatives and strategically hand-picked judges be permitted to dictate the deeply personal healthcare decisions of millions of American citizens? It fundamentally tests whether science and empirical evidence will genuinely guide our policies, or whether divisive politics and rigid ideology will simply override them. That sets a dangerous precedent for all regulated industries and the very integrity of the scientific process in policymaking. Ultimately, this fight is about protecting the basic, fundamental right to control our own bodies in the 21st century, a right that has been vigorously challenged in recent years.
From deeply personal health decisions to the far-reaching implications of executive power, let's now turn to a truly consequential courtroom showdown that is actively testing the very limits of presidential authority. Newsom v. Trump. This isn't really about one isolated protest or one specific city. It's about a fundamental constitutional question. How much power does a president actually have to unilaterally deploy military forces inside the United States? The case is currently being heard in federal court with Judge Charles Breyer, yes, the respected brother of former Supreme Court Justice Stephen Breyer, at the helm. So, to fully grasp the context, we're talking about the widespread protests that erupted in Los Angeles following a series of controversial ICE immigration raids. At that time, Donald Trump, then president, issued orders to deploy federalized National Guard troops and even active-duty Marines into L.A., ostensibly to control the situation. California's Governor Gavin Newsom immediately challenged this action, stating unequivocally that Trump couldn't just swoop into my state with troops without my consent, arguing it was a violation of state sovereignty.
So, the core legal question squarely at the heart of this case is, was this specific deployment lawful under American constitutional principles? Or did it, in fact, constitute an unconstitutional power grab? Did it directly challenge the Posse Comitatus Act, that foundational federal law from 1878 that sharply limits the use of the U.S. military for domestic law enforcement purposes and threaten the Constitution's meticulously designed balance of power between the federal government and the individual states?
A fundamental challenge, then.
Absolutely. This case forces a direct confrontation with the separation of powers.
But before we even dive into the actual legal arguments, I want to highlight a concerning issue of transparency. Because this trial, incredibly, almost happened entirely behind closed doors. Initially, the public actually could watch the proceedings live via a public video feed, which is rare for federal courts. But right before the trial was set to begin, the Trump administration successfully petitioned the judge to shut off that video feed, claiming one of their key witnesses, an ICE official, faced potential safety risks if their face was broadcast publicly.
So they pulled the video feed last minute.
Just like that, the public video was gone. We're now left with only an audio feed. Don't get me wrong, audio access is certainly better than nothing, but there's genuinely nothing quite like seeing the courtroom yourself. The hesitation in a witness's voice, the telling body language, the subtle facial expressions when tough questions are posed, all of that contributes to credibility assessment and truly matters in understanding courtroom dynamics. And when you take away those visual cues, you inherently take away a significant part of the public's ability to truly hold power accountable and fully comprehend the proceedings.
You're absolutely right. It's an important point. We routinely televise trials in state courts. Think about the Derek Chauvin trial, fully televised, and that visual accessibility mattered immensely for public understanding and accountability. Federal courts, by contrast, very rarely permit cameras. Even the Supreme Court only allowed audio during the peak of COVID. So the fact that this particular trial began with video and then suddenly had the plug pulled based on a late-stage motion feels incredibly deliberate.
Suspicious, even.
It creates a strong impression that someone didn't want the public to see what was happening, generating a fascinating and disturbing tension between legitimate security concerns, which are important, and the vital principle of judicial transparency in high-stakes cases, where public scrutiny is arguably most necessary.
And let me tell you, that suspicion of deliberate obfuscation isn't unfounded, because once you listen to the audio feed, it becomes remarkably clear. This case is unequivocally not going well for Trump's legal team. Judge Charles Breyer is a highly respected, deeply experienced judge known for his incisive intellect and rigorous questioning. California's lawyers meticulously laid out their case, arguing that the president simply cannot declare a rebellion at will and send in federal troops without proper constitutional and statutory justification. They emphasized that there must be limits. That's the entire point of the Posse Comitatus Act and the Constitution's delicate balance of power. Judge Breyer listened intently, letting them make their argument with minimal interruption. But the moment the Justice Department's lawyers stepped up to defend Trump's actions, Breyer immediately unleashed a flurry of tough, direct questions.
He pushed back hard.
Oh, yeah. He pressed them relentlessly. Where are the limits here? If a president can simply declare something a rebellion at will, without any discernible factual basis, doesn't that fundamentally mean there are no checks at all on their power? Does that imply the president could federalize troops whenever he wants, for whatever reason, effectively transforming our military into a domestic police force?
His tone during this questioning wasn't casual or merely academic. It was sharp, even visibly indignant. You could distinctly hear the profound frustration in his voice as he pushed back on the government's arguments. This is an extremely significant indicator because in a bench trial like this, where there is no jury, the judge is the sole fact finder, the ultimate arbiter of credibility, and the one solely responsible for weighing all the evidence. If you have the judge himself sounding exasperated, even seemingly incredulous at your legal arguments, that signals a very, very serious problem for the defense. It's an unusual public display of judicial skepticism in a federal courtroom.
But it actually gets even worse for Trump's side. Their key witness, Major General Scott Sherman, took the stand. On day one of his testimony, he made a crucial admission under questioning. He stated unequivocally that no one at the Pentagon had ever described the protests in Los Angeles as a rebellion.
Not a rebellion.
Exactly. He clarified that that specific, legally loaded word rebellion had originated directly from Trump's team, not from military intelligence or assessment. This was a colossal moment because under the existing law, a declared rebellion or insurrection is often the precise legal trigger for legitimately deploying federal troops domestically. If even the military's own assessments didn't view it that way, the entire legal justification for the deployment begins to crumble. But then came day two of the testimony. The very same general suddenly and conspicuously changed his tune. He clarified that, oh yes, of course everyone knew the president had issued a memorandum calling it a rebellion, and they were simply following orders. Folks, if you listen to the audio, you could literally hear it in his voice. A palpable discomfort, a discernible hesitation, like someone frantically backpedaling after realizing they'd said far too much the day before.
It sounded like damage control.
It didn't come across as a confident correction. It sounded like damage control, pure and simple.
And here's the critical takeaway. Judge Breyer, an exceptionally seasoned and astute jurist, was meticulously observing all of this. He's no rookie. He instantly recognizes credibility, and he certainly knows when a witness is fumbling, inconsistent, or visibly changing their narrative under pressure. That's precisely why this particular testimony matters so immensely. Because unlike a jury trial, where 12 different people might interpret things differently, here it's one man's singular judgment that counts. And if he picked up the same palpable unease, the same inconsistency we heard on the audio, then the Trump administration's defense is in profound trouble. This raises a crucial question about the judicial process. How significantly does a witness's demeanor and a visible mid-trial shift in their testimony impact a judge's perception of their overall credibility, especially in a bench trial where the judge is the sole ultimate fact finder? It suggests that the perceived truthfulness of the witness can be as influential as the facts themselves. Let's zoom out for a moment and consider the broader implications. Why does this case matter beyond California or beyond just Donald Trump's presidency? Because if Trump's sweeping legal theory wins here, it would establish an incredibly dangerous precedent. It would fundamentally suggest that future presidents could unilaterally deploy federal troops anywhere, at any time, for any reason, with virtually no real check or balance on that immense power.
A major shift in power.
Huge. Judge Breyer himself explicitly warned about this during the proceedings, cautioning that such expansive legal logic could pave the way to a national police force, a concept that the founders of our nation meticulously sought to prevent by placing strict civilian and state-level controls on military power. The broader significance here, host, is profound. It highlights a fundamental challenge to the Constitution's carefully designed structure, which meticulously limits federal power and robustly protects the principles of federalism and states' rights. We've observed a consistent pattern. During the COVID-19 pandemic, courts briefly opened up public access, which often exposed the inherent weakness of many of Trump's legal arguments, particularly those challenging the 2020 election results. This attempt to close the public window in the Newsom v. Trump case appears to be a consistent part of a larger pattern of trying to limit transparency when legal arguments are perceived as weak or politically inconvenient.
So what's the current status of this high-stakes case? Judge Breyer hasn't issued his ruling yet, but his profound skepticism during the proceedings has been pretty obvious. He clearly understands this case isn't just about one isolated protest in Los Angeles. It's about a much deeper foundational question: whether the Constitution still places meaningful, enforceable limits on executive power, particularly concerning the domestic deployment of military force.
This trial is undeniably historic. It's actively testing the very balance of power between the states and the federal government in Washington, D.C. No matter how the judge ultimately rules, the decision will profoundly shape the interpretation and limits of presidential authority for many years to come, fundamentally influencing how future executives might interpret their powers concerning domestic military deployments. It will be a landmark ruling that will be studied for generations.
Now, for our final deep dive today, let's turn our attention to something that's often joked about as a political cliche, but which is becoming increasingly and alarmingly real: the tumultuous state of a major American political movement. You know how the common cliche often goes, Democrats in disarray? Well, right now, it certainly seems like the Republicans are the ones who can't keep their house in order. And believe it or not, the latest dire prediction about the potential collapse of the Republican Party is coming from none other than, wait for it, Laura Loomer.
Yes, that Laura Loomer, the fiercely right-wing firebrand, the self-proclaimed MAGA ride or die, the provocateur known for her aggressive tactics and rooting out what she perceives as so-called disloyal figures within the movement. The significance here is truly profound. This stark prediction of the GOP's imminent collapse post-Trump is not emanating from critics, not from the opposition, but from one of MAGA's loudest, most fervent, and most unyielding cheerleaders.
Coming from inside the house, so to speak.
Exactly. What's particularly fascinating here is how often internal figures, those most intimately embedded within a political movement, often offer the most scathing and, at times, perhaps surprisingly accurate self-assessments of that movement's vulnerabilities and inherent fragilities. They see the cracks from the inside.
So let's get into the specifics of Loomer's core argument. Here's exactly what she posted recently on X, formerly Twitter. I don't think the GOP is going to survive post-Trump. There's too many conflicting personalities trying to jockey for the mantle of MAGA, and none of them have what it takes to be Trump's successor. We are witnessing the end of a future post-MAGA movement as we know it. Everyone inside this so-called big tent the GOP forced on us realizes they all hate each other. There won't be a viable political movement post-MAGA. You can see the writing on the wall. Nobody has what it takes.
Wow, that's blunt.
This isn't just criticism. This is a scorched earth statement. She's essentially asserting the second Trump exits the political stage, whether it's in 4 years, 2 years, or whenever that moment arrives, the MAGA movement as a cohesive force is over.
Yeah.
It was never truly built to outlive him.
And honestly, hosts, she might be onto something incredibly profound and uncomfortably true, because if you strip away the intensely personal, almost unquestioning loyalty to Trump himself, what truly remains? What you're left with is a collection of ambitious personalities who certainly covet the crown of the movement, but simply do not possess the unique charisma, the singular star power, or that almost cult-like, deeply personal grip that Trump holds over his base.
That Fifth Avenue quote comes to mind.
Right. Trump himself once infamously boasted, "I could stand in the middle of Fifth Avenue and shoot somebody, and I wouldn't lose voters." As disturbing and hyperbolic as that statement was, the uncomfortable truth is he wasn't exactly wrong about the steadfastness of his support. This profoundly illustrates the truly unique, deeply personal, and effectively non-transferable nature of his base's loyalty. It's built entirely around him, the individual, not a traditional ideology or a conventional party structure. And that's a very fragile foundation for any long-term political movement.
So this brings us squarely to the million-dollar question that looms over the Republican Party. Who comes after Trump? People in the media and political circles constantly float names. J.D. Vance, maybe Elise Stefanik, perhaps Ron DeSantis, if he can somehow claw his way back from what was, frankly, a disastrous early campaign flop. But let's be absolutely real here. None of them possess his unique Trumpness.
That undefinable quality.
Exactly. Take J.D. Vance, for example. On paper, he embodies everything the Man J movement could ostensibly want. He's young, articulate, a true believer now, after once being a vocal critic. But does he genuinely excite a crowd? Can he pack stadiums the way Trump consistently does? Can he get people lining up overnight, enduring extreme weather conditions just to see him speak? Absolutely not. There's a distinct energy gap.
And history consistently provides us with clear indicators of what happens when Donald Trump isn't directly on the ballot. Look at 2018. Republicans suffered significant losses, ceding control of the House. Look at 2020. They lost both the presidency and control of the Senate. And consider the numerous Trump-like candidates who ran in 2022, figures like Dr. Mehmet Oz in Pennsylvania or Herschel Walker in Georgia. They attempted to ride the Trump brand and mimic his style, but without Trump himself actively campaigning for them, they simply fell flat at the ballot box.
The coattails weren't strong enough.
Precisely. The proof, host, is irrefutably in the numbers. Trump's base is overwhelmingly loyal to him. Not necessarily to the Republican Party as an institution, not even to the stated Maji movement as a distinct transferable ideology. It truly is, at its core, a cult of personality. And when the central magnetic personality that defines such a cult is gone, historically speaking, those cults tend to fracture, dissipate, and ultimately collapse.
Now, here's where things get even messier and more chaotic. Because it's not just about whether the MAGG movement can survive without Trump, it's about the undeniable fact that even while Trump is still very much a prominent figure, his so-called allies within the movement literally cannot stop fighting each other. Case in point, a perfect illustration, the ongoing highly public feud between Laura Loomer and Congresswoman Marjorie Taylor Greene.
Oh, that feud.
Right. These are two women who, on paper, should ostensibly be on the exact same side. Both are staunchly far-right, both fiercely pro-Trump, both prone to outrageous and often controversial statements. And yet, they absolutely despise each other. It began over relatively petty disagreements, but it has rapidly snowballed into full-blown vicious character assassination. Loomer has publicly accused Greene of being a fake Christian, a liar, and probably the dumbest person in Congress.
Ouch.
Greene, for her part, has retaliated, calling Loomer a coward who disrespects American heroes. And you know what specifically sparked this latest, most venomous round of their feud?
What was it this time?
Loomer criticized the U.S. Army for honoring Florent Groberg, a Medal of Honor recipient who literally tackled a suicide bomber in Afghanistan, an act that saved the lives of his fellow soldiers while he himself suffered catastrophic, life-altering injuries. Loomer dismissed him, not for any military failure, but because he had once criticized Trump and because he was a naturalized citizen. Let that sink in for a moment.
When Marjorie Taylor Greene, a figure who herself is widely known for her own highly controversial statements and often extreme rhetoric, starts looking like the sane one in a political fight. Oh boy.
Man, that's saying something.
That host tells you precisely how far gone the other person is, and it vividly illustrates how extreme rhetoric, deeply personal attacks, and a profound lack of internal discipline can thoroughly and completely undermine any semblance of cohesion within a political movement, even among those who are ostensibly aligned on the same ideological side. It's a sign of deep internal rot.
So while Democrats are consistently hammered by the media with the perennial Democrats in disarray narrative, maybe it's high time we started applying that very same label to the Republican Party.
Right now, the Maginot Movement, as anything resembling a cohesive, unified political force, looks alarmingly like a snake devouring itself. On one hand, you've got Trump's fiercely loyal and often fanatical supporters, figures like Laura Loomer, who genuinely believe no one can ever truly replace him or replicate his influence. On the other, you've got a cadre of ambitious figures like Greene, Matt Gaetz, Kari Lake, and others, all aggressively trying to carve out their own piece of the pie and strategically position themselves for future leadership roles within the vacuum that will be left.
Knives out, basically.
They may present a united front for the cameras, but behind the scenes, it's clearly knives out, a brutal internecine struggle for power and influence. It's not a question of if there's going to be a civil war in the GOP after Trump. It's very much a question of when. And frankly, the early skirmishing battles are already being visibly fought and bleeding into public view, indicating a profound and potentially irreversible schism.
Here's why all of this matters directly to you, the listener. When a major political party fractures in such a profound, public and personality-driven way, it doesn't just remain an inside baseball story confined to political pundits. It directly and profoundly impacts elections. It fundamentally shapes who controls Congress, and it ultimately determines who will occupy the White House. This infighting has tangible consequences for the direction of the country.
The potential scenarios stemming from this internal conflict are significant and far-reaching. If Republicans truly cannot unite post-Trump, or if the internal divisions become too deep to bridge, Democrats could find themselves with a huge, perhaps even sustained political advantage for years to come. But conversely, and equally concerningly, if the Maggi faction doubles down on its extreme, personality-driven focus, the GOP could become less like a traditional political party and more like a personality cult that lashes out fiercely, even violently, at anyone who dares to question the dear leader, even if that leader is no longer in office or even alive.
A very unstable situation.
Extremely. That host is precisely the chaos and destructive fragmentation Loomer is inadvertently talking about. Even she doesn't fully realize how profoundly right she might be about the truly long-term implications for American democracy. This raises a crucial, overarching question. What kind of political landscape truly emerges when one of the two major parties undergoes such a profound, personality-driven transformation? And how does that fundamental shift impact the stability, functionality, and very nature of democratic governance and the accountability of those in power?
We've truly taken a deep dive today into the incredibly complex legal and political landscape surrounding Donald Trump. We've explored the unprecedented financial accountability from the E. Jean Carroll cases, peeled back the unsettling layers of the hidden scales of abuse networks connected to his orbit, examined the high-stakes fight for medical access involving mifepristone, and analyzed the fundamental challenges to presidential power in the Newsom v. Trump case, right down to the intensifying internal strife within the Republican Party itself.
This exhaustive journey through multiple legal and political challenges really raises an important, overarching question for you, the listener. What does it truly mean for a democracy when a significant, indeed arguably dominant portion of its political discourse and legal battles revolves so intensely and singularly around one central, highly polarizing figure? And as we navigate an era where political movements are increasingly defined by the charisma and persona of an individual rather than by pure, enduring ideology, how does that fundamentally reshape the future of governance, the mechanisms of accountability for those in power, and the very health of our democratic institutions? This is certainly something worth mulling over long after this deep dive concludes, as its implications will ripple through our society for years to come.
We hope this deep dive helped you connect the dots, cut through the noise, and gain a much clearer, more nuanced understanding of what's truly at stake in these complex, interconnected narratives. Your curiosity fuels these conversations, and we genuinely love sharing these insights with you. Thanks so much for joining us today, and we'll see you next time on The Deep Dive.